So very good afternoon to everyone. So I welcome you all on behalf of the Center for Sustainability and Corporate Governance Research. So it's my great privilege to welcome the guest speaker for today's seminar, Professor Srividhya Ragavan. Professor Srividhya Ragavan is currently a professor of law and director International Law Program at Texas A&M School of Law. Her research brings together three distinct areas of expertise: 1, access to medicine and healthcare; 2, intellectual property; 3, trade and development. She is also a member of a law school's top-ranked Center for Learning Intellectual Property Rights. Professor Srividhya has published more than 6 books and more than 100 plus law review articles, book chapters, public policy reports. Her expertise is frequently highlighted in different Indian media outlets such as the Hindu Business Line, The Hindu, DNA, Live Mint, and All India Radio. She has also represented India's interest before the US International Trade Commission and at the Office of US Trade Representative, USTR, on access to medicine issues. She serves in the leadership role at several professional organizations, including Association of American Law Schools, International Law Association, and Research and Information System for Developing Countries. Professor Srividhya holds BA LLB honors from National Law School of India, University, Bangalore, and she earned a merit certificate from NLSIU, Bangalore. She holds LLM from King's College, London, and she completed her Doctor of Juridical Science, that's SJT, from George Washington University Law School. So topic for today's discussion is balancing intellectual property, ESG, in the healthcare sector. So generally, intellectual property is considered as a negative right. Reason being, it tried to give a kind of a monopoly right for the IP holder for a certain period of time. Also, it prevents the competition. Also, it gives higher upper hand to the patent holder or intellectual property holder to charge maximum price for any particular patented drug, processed patent or processed like product patent, very, very high maximum market price. But there is an inbuilt tension between private and public divide. In fact, there are certain tools available under the intellectual property law to achieve public policy goals such as compulsory licensing, technology transfer to mitigate the climate change, and sustainable development and various other things. So Professor Srividhya is going to draw balance between these two different tension areas within the area of intellectual property, that's IP and the ESG sector, with specific focus on healthcare sector. All right. So I welcome you, Professor Srividhya, once again to the IIMA and to the center. Yeah. Thank you so much. Yeah.
Thank you. Thank you. I appreciate the very kind introduction. I'm used to doing this in my home institution. The tallest in my law school is 6'7". So, and sometimes I end up teaching after him, after Felix Mormon. So I'm used to doing this. Thanks everybody. So my presentation, as you can see, is on balancing intellectual property and ESG in the healthcare sector, right? So I begin with, what I'm most comfortable with, which is patents. Originally, patents were envisaged as a very, very good thing, right? When we began, we thought of patents as, something that would lead to, that will continue to spur creativity, incentivize others to continue to build on what is built. And we thought that, patents would help public as a whole. So that was the original, that's how we envisaged patents as a whole, right? But the wheel of innovation has continued to roll. Today, patents is one of the best business tools. If you want to, assert a right, sometimes you may not even have innovation in it, but you may still find rights in it. So I always tell my students that intellectual property, you should always compare it with real property, right? And sometimes you only get barren land, but people manage to make money out of barren land too. They sell it for warehouses, they rent it for warehouses, right? They rent it for cows to graze sometimes, right? And that's what patents have become today. So it has a twin avatar today. On the one hand, right, patents can be used, to protect and promote innovation. On the other hand, patents, of course, is a great business tool if you can strategize accordingly, right? Now, when we talk about patents today, I want to contextualize it with its flawed romance with trade, right? Of all the romances human beings have, it's the flawed ones that are consequential, right? Whether in our lives or, no, really, whether in our lives or in law or in any other area. So the flawed romance with trade, which today is memorialized as part of the World Trade Organization's TRIPS agreement, right, positions patents in a completely intellectual property altogether, but certainly patents in a completely, different way. Pharmaceutical patents has largely reset the global trade agenda. Because for the first time, I want to, I don't want to stick to the slides really. For the first time when we signed the World Trade Agreement's TRIPS agreement, right, I need us to appreciate that trade became the focus of the entire agenda. Everything else was subservient to trade, right? And so health, which was an important cog in the wheel, was nevertheless, the focus was from a trade vantage. Does it, how can it, will it improve trade, right? So what we forgot at that time, and we continue to forget mostly, is that health is directly, right, a component of national productivity. When health deteriorates, national productivity deteriorates. When that deteriorates, global trade deteriorates because supply chains get affected, right? And there is no transfer of technology, which is all the main reason why the romance began to begin with, right? So we have to remember that, right? Trade remains the main goal, right? And in the process, public health became a casualty. When I was a younger professor, this proposition used to be challenged. How was it a casualty, Shri? Tell me how, public health is a casualty. Post the AIDS conundrum, post COVID, this is now a global reality. It's not even a, it used to be a poor country story, then it used to be a developing country story, and now it is a global story. If anything, that's what the World Trade Agenda contributed, right? So public health is a global issue now, right? Including the American elections, right? Focused on public health, healthcare access to Americans. So we have to always remember that, right? So part of it is the inequities we see in the bargaining parities of parties, right? So one of the best conceptual aspects of the World Trade Organization is juridical equality, right? However, right, the bargaining, in reality, juridical equality did not translate into equal rights, right? It's the same. We always say, right, women have the same rights. I'm a woman and I always say, yeah, right? I don't know how many of you are law graduates here. I used to teach first year contract law, right? Entire law of contracts is taught from the vantage of what we call as a reasonable man. How will a reasonable man construe it, right? I mean, reasonable man, anybody exists like that, right? Give one of them, right? So a lot of times these are all legal concepts which operationally brings a lot of issues, and that's what we live in today, right? So the inequities in bargaining parities have resulted in what we see here, right? There is a public health crisis. Access to medication is now, it started with, free trade became a lobby politics. Global realities made public health a global crisis. It has become a developed country problem, and that in turn positioned IP as one of the biggest barriers, right? And we have seen that being reiterated in report after report, UN report, WIPO Global Agenda, Lancet, WHO, all of these ultimately said, look, we have to look at intellectual property from a slightly different perspective when it comes to public health, right? And when it comes to global realities, what are the issues we see? Pricing, patent policies and patent regime, And last is WTO's normative textualism, a very, very, I want to say very, very, I want to say hardcore legal concept, right? It's textualist approach to what is written with no dose of realism, right? It does not take local realities to interpret its own statutes. And that has created problems in different parts of the world. And how do we define these problems? Development has happened, but they don't seem to be sustainable, right? So when textualism is directly has directly resulted as, right, unsustainable development in pockets of the globe, right? So with all of this, with this vicious cycle, we are at the point of environment and social governance. So suddenly we are like, oh my God, we have to really look at the world around us, and there is a need for ESG. So when we look at ESG, or obviously environment, social governance are the three factors, right? So I have a question. I'm not very good at lecturing. I'm actually much better at talking and making jokes and things like that. So it becomes easier, right? What is the one thing that connects all three of this? What is the one thing that you think when we talk about ESG, what can make a difference? How will ESG manifest in our lives? What's the tool to manifest ESG in our lives? Say that loudly, old woman. Public health. But even changes in the public health, where will you get that from? I'll take it. The most abused person, Mother Nature, but still, what is the tool to actually, if I want an ESG based change today, what is my tool to make that happen? Policy, right? And who are the policy makers? Government, and government consists of legislatures. Legislatures are typically lawyers, right? So policies are the most important tools that can make a difference to this whole thing, right? Policies, the legislature, and ultimately the law. It's a potent tool that has to be used appropriately to create changes, right? So now we look at what ESG factors, because our focus is healthcare, what ESG factors affect healthcare, right? So public health, health equity, ability to get access to health. It used to be again a problem in poorer countries. UK has a problem with its NIH. US has no healthcare. I mean, Obamacare, which will now of course get repealed, and then it becomes harder, right? A lack of resilient supply chain. Accelerating R&D, because on the one hand is access, on the other hand is research and development, right? We want new medications and drugs to happen. Enhancing digital, data, innovation in data protection, etc. And most importantly, climate change. Right? So these are only a sampling of things. ESG has an impact, much bigger global impact, but these are a sampling of things, right? So we now look at public health and ESG as a factor. What type of things do you think would enable health equity, right? Now, if this was US or even if this was Europe, and if I asked my students and if I tell them, what do you think? Right? And of course, I work in a law school, so it's a little bit different. But if I tell them, what would you think would enable health equity? I want all of you to answer that question. If I tell you, go out into the world and try to make health equity happen, what is the job you will take to do that? Sorry? Generic medicines, but still, what's the forum to create health equity? You want the country to say everybody gets access to medicines. How will you get people to say that?
Immunization accessible to all.
Right. How will you get that to happen? Who will tell the legislature? That's the next question. We have already established that policies, legislature, law is a good tool, right? Who is going to help who is our health minister? Pick up the pen and say, okay, now everybody gets medicines in India. Who's going to do that? Who has the potential to do it? And how do they make it happen? Say it. Oh, they're old. They've in every country they are disconnected with the reality. Old men too, to double disadvantage, right? Not just old men. Sorry, you were saying something. I'll take it and I want to change it by creating sufficient lobby politics, lobby groups, whether NGOs, lawyers, right? You need, lobbying, right? So before we get to that, when we talk about pharmaceutical industry, what is the pharma industry? Tell me, you said generic drugs. What else is pharma industry? Tell me. What are the type of drugs? Don't give me Ayurveda and all that. Let's just take modern, the kind that we are not able to afford, even though it is there. Let's only take that drugs into consideration, okay? So what are the different types of drugs that we talk about? Okay, and what are they? What are the two major types? Say it. I'll take prescription and generic. Generic and anything else? Okay, I'll say it, right? So chemical drugs, right, can be innovative chemical drugs. The first time when it's high priced, right? Let me give you some examples. Nexium, what's the allergy medication? Allegra, I think Allegra is the generic version, I believe. I'm not sure now about Allegra's, right? If you have innovative chemical drugs, and what is the opposite of innovative chemical drugs? Generic drugs, right? What are biologics? Vaccines? Huh? Yes, Semaglutide, insulin. These are made from live, right, cultures. And therefore, it's much more expensive. The equivalent of an innovative biologic is called a biosimilar, right? India wants to be in this business. If we can afford this, even America will do better. Not that India should afford, even in America, biosimilars are not there, right? For a rich country. So this is your entire pharmaceutical industry. Innovative chemicals, biologics, equivalent is generics or biosimilars, right? Okay, now I go back to my question. If this was US or Europe, and then I tell my students, hey, let's do some health equity thing. Half of them will say, well, which lobby group can I work in, right? So the first thing is, how do these lobby groups translate? Either they work for a lobby company or they go and become a part of government and the legislative affairs department of companies, right? What do? Right? They lobby, right? Usually, these companies will have academics, right, for impartial notes, lawyers to write the policy, management folks to give data, right? When a policy is given, then management folks step in, and then management folks say, look, this is a great policy, we'll have industry, but this much of society may get access to drugs, but this is the amount of money the government may get or lose over a 10-year period, this is the projection, right? And if the projections are not good, we go back and the lawyers will rewrite the policy and the government affairs will go up and do it. So it's usually an interdisciplinary work with 3 or more fields, although not in India. India will go to KPMG, McKinsey, we'll forget the lawyers, unfortunately, right? But that's how, usually things happen, right? Then we create expertise in the area in the board or as advisory board members. We have board and advisory board members who are able to, crunch these data and then take it for take it for political lobbying. Right? How does ESG interact here? We are talking about two different things and we have to get them together into the same table, right? Okay. This is where IP intersects with ESG. When we talk about social, we are talking about access and health equity. When we talk about governance, we talk about policies that can facilitate access and health equity, right? And when we talk about environmental, it need not just be the trees and the cows, right? It's the health environment, right? We define the scope of what we call as environment for each thing that we write about, right? So it could be climate policies, public health, the health policy environment, right? All of that together will fall within the larger agenda of ESG. Right? So now that we see how one can position health, IP and ESG, right? We look at the last prong, which is where do organizations fit in? So they take each of these things and position that as responsibility and accountability, right? Because it doesn't matter if you have all of this, you still need responsibility, organizational responsibility, which is useless unless there is accountability. There has to be oversight and accountability, right, at some point in time, right? So again, we are still living in, what would happen, what kind of things. Usually, lobby groups will make a list of international issues that will affect ESG. Then a list of national policies that will get impacted. You create I need this list, right? And then I want this list, right? The idea being you're not going to get everything you need, you're not going to get everything you want, right? Of course, want trumps it, so you ask for more. Whatever you need, sometimes you would get that, right? So you create a list of international, national policies and then try to get your wants and your need and hope that you can at least hit some, hit some targets there, right? So we actually as lawyers, it's a good joke. You're all looking tired and I have more slides, so I'm going to say this, right? So as lawyers, what do we say? You create your want list. As soon as you go there, I would say, I want to be tall. Of course, they're going to say you can't be tall, right? So then I say, no, I want this, I want that. And people negotiate, right? And then, of course, it's what is the climate today? Climate is nice and cold. Crank up the heat, make it 82 degrees and she's looking, I have to go back to my hotel. Then, when it's hot, you create your want list. Okay, I needed 100 things. I'm going to zero it down to 5. Give me 4. I'll walk out of the table. Right? So you really have to work between your needs list and your wants list, right? And negotiate between that, right? And that's where licenses kick in. We are not doing anything on licenses there. That's where sophisticated licenses, right, would kick in, right? Okay. So I want to take examples from the international healthcare policies that affects ESG. And I only take 2. One is the Innovation Transfer of Technology Framework and next is the Regulatory Approval Framework, right? So I want to go first to the International Innovation Transfer of Technology Framework and give you 2 examples. The 2 examples are from the TRIPS agreement. One is called Limitations and Flexibilities. The other is called Local Manufacturing. Okay, I don't know if this is too legal, but I still want to talk about this. What is a limitation and flexibility? You remember COVID? India wanted a waiver so that it can distribute vaccines more freely. Do we remember the AIDS crisis time? Brazil wanted to lower the cost of medication so it could distribute more freely, right? All of this is facilitated as a limitation under Article 30 of TRIPS. We are not talking about flexibility. What is the flexibility? That pen is yours. Can I take it? Is a flexibility, right? So which means that is yours, then you give that to me. Same thing translates with IP rights as well. It's your right, I take it, is a flexibility, right? What is a limitation? I don't have a pen. Don't make me write now, right? So I draw my line. You can't make me write now, right? Versus, can I borrow your pen? And then you're kind, you're giving me a pen. Now I'm indebted to you, right? That's the difference between a limitation and a flexibility. Article 30 says limitations can happen in 3 steps under the TRIPS agreement, right? Governments can limit exclusive rights of patents, right? If it's confined to special cases, AIDS, COVID, right? Does not prejudice rights of IP owners and cannot conflict with the normal use of the work. I am saying I want to limit, right? It's a limitation. I want to say I need your pen. That's a limitation. But TRIPS is saying, yes, you can take his pen, provided it doesn't affect his work. It is virtually impossible, right, to exercise Article 30 limitation under the TRIPS agreement, right? Limiting rights without normal exploitation of rights, am I right, is virtual impossibility. Who does that, right? It takes international policy makers from the Swiss to do this, right? Policy change can help these kind of policy changes, we have never, ever, India or Brazil or BRICS have not ever gone back to the limitations question. There is an appellate, WTO appellate dispute resolution on this question, but after this, we have never tried to challenge it, not even during COVID. This kind of policy will help both generics and ESG goals, right? Let me give you another example, right? We talked about limitations. Let me give you local manufacturing as a flexibility, right? What is the difference between does our international obligation, whether America, India, our is a general term I use, allow local manufacturing? Yes, no?
It depends on sector to sector.
Okay. No. We are only talking healthcare. So let us assume COVID, okay? There is a vaccine produced by, I don't know, some Pfizer, immediately cures COVID in the next 20 days, 20 minutes, whatever it is, right? Bharat Biotech wants to manufacture it. It is a patented vaccine, right? And Bharat Biotech is willing to pay the license fee. Is that allowed under the TRIPS agreement? Absolutely. It is not allowed. That was one of the biggest issues in Justice Prabha Sridevan's decision on Bayer's Nexavar. Why is local manufacturing not allowed? Local manufacturing affects trade. The whole trade agenda is we will manufacture, you reduce the trade barriers and reduce the tariffs, and we will import it, right? As long as there is a patent on it, right? So patented cancer medications, that is why Gilead gives voluntary licensing. That is why India wants compulsory licensing, which is a flexibility. It's like literally begging, please, can we have some rights, right? So that's your compulsory licensing, right? So your local manufacturing, which is the easiest solution for supply chain issues. Why cannot India and China and Philippines produce and distribute regionally some of these vaccines and cancer drugs at a lower price, right? The only way you could do it is if you compulsorily license it. And, right? Am I right in saying that, right? Okay. So local manufacturing would result in automatic transfer of technology and innovation. It will automatically lead to more innovation in these sectors. Are you with me so far? Does that make sense? Right? And it is not allowed. But that's not just here. Other countries, right, have pushed for local manufacturing. When America had an insulin crisis, and I don't know how many are aware of the insulin crisis in America. When India had 99 generics, America did not have even one insulin without patents. Right? Every one of those was patented. In fact, a University of Toronto scientist first patented it in the 1800s. For over 100 years, different versions of insulin had been patented in the US. Right? And only last 2 years back, 2022, Indian Biocon launched the first insulin biosimilar called Semegle in the US. Right? So at that time, Governor Newsom, right, immediately said we are going to locally manufacture in California. Africa is now having a sustainable vaccine manufacturing policy in order to locally manufacture and create transfer of technology. What's his name? The Dallas Mavericks owner. Mark Cuban. Mark Cuban has now started his own healthcare pharmaceuticals, right, and basing it on local manufacturing and eliminating middlemen, right. So these are some of the policies that one has to push for. It will automatically lead to some healthcare benefits and lead to some of the ESG goals, right. Okay. So this of course will make supply chain better, but the most important thing is health equity won't be a byproduct of charity. It won't be like America is like, oh, we'll give you the vaccine technology. No, we don't need it, right? We have the potential, the scientists and so on and so forth, right? All we need is sustainable policies that will develop and help local manufacturing, local industries and cater to, right, local governance, right? So this is one. But when we talk about healthcare industry, right, and ESG, I repeatedly see more from India, but from all over the world, people don't look at policies. Instead, this is what I see. Healthcare faces huge risks with climate change, and then it talks about resilient supply chain, increase agility, maintain optimal inventory, improve visibility. I'm not saying no to any of that. But unless you have sustainable policies that will make, changes from the ground up, these are all, these will make a difference, but those can make a much higher, bigger difference, right? Are you with me so far? Right, another one, this is one of my favorite. It came from one of these big consulting groups, right? What was this? Setting sights on net zero emission, right? And I mean, in the Trump era, zero emissions we are going to look at, right? We don't even believe there is a climate crisis yet in the US. Protect public health by create healthy living and workspaces. I'm like, who's investing in that? Healthy, and how do you create healthy living and workspaces? Right? Again, go back to policy. So all of these alternate energy sources, smart Elon Musk now, one of the, right, he's not going to let Chinese alternative energy come in there, right? So it's all smart supply chains. I'm like, okay, medical recycling, all of this again should go back to policies, right? We are going to do all of this without local manufacturing, with no import-export reconciliation. I think it's going to be really hard to get that to happen. Any of these, all of these are perfectly fine things. There is nothing wrong with any of this. But to get here, you have to get there first. We are missing the first beat is what I'm trying to say. Okay? Okay. Now, examples of international, we look at two. We looked at innovation framework. I want to quickly look at something called regulatory approval. What is regulatory approval? You have a new drug, a patented drug, let's say Tylenol that now cures, what can it cure? I can't think of anything. Tylenol that now cures cancer, right? Right? You have to get the drug approved by who approves drugs? FDA, right? FDA has to approve drugs. Last year or maybe early this year, India has a new regulation. I don't know how many of you are aware. When a drug is approved in the US, UK and 3 other places, it is automatically considered approved in in India, right? And that's most management experts want us to follow US approval process. Why? Because it is the time-tested process, right? So I just want to give you a tidbit. This is an area of my expertise, so I'm happy to give you a little tidbit about how biologics get approved in the US, okay? And I'm fairly certain you'll find this let's file a biologics are approved. Biologics are cancer drugs, okay? So let's call it Tylenol. Tylenol is already approved. Bharat Biotech from India is now filing a biosimilar, okay? Biosimilar is the equivalent of a biologic, right? It low cost will be available, okay? So biosimilars also need investment and so on. These are large molecule drugs and all of that. This is all, you know, things that you can see. These are highly similar with no clinically meaningful difference. So your doctor can prescribe a biosimilar instead of a biologic. We are right there, okay? Okay. So the process for getting a biologic approved is called the ABLA application, abbreviated biologic application, because your biologic has already been there, and abbreviated drug application is what it's called. FDA approves the BLA first, biologic is approved. Bharat Biotech is getting ready, testing biosimilar, tested now. Bharat Biotech is filing its ABLA application. With me so far? Bharat Biotech now launches its flag in the US. We are all very happy, okay? FDA won't touch that application for 4 years. For 4 years, it is called regulatory data exclusivity. You can file the biosimilar application on the next day. No FDA commissioner has statutorily prohibited from touching the application. Okay? So now I am the commissioner, I have touched the application. Application goes through. Statute has a process called patent dance. The entire process takes 245 days. How many months? Please tell me. 8 months. Whole process of patent dance is 8 months. Then patent dance is to lead to the biologic to sue Bharat Biotech, the biosimilar. At this stage, we commence the first stage of the patent dance litigation. Okay? So, are you with me so far? Litigation commences. Then litigation ends. I won't get into what happens here. We'll talk about that in a second. Okay? Then FDA approves the ABLA. Okay? Already you've given up 4 years. By the time first patent dance ends, usually there is a market exclusivity, and the litigation stage, it takes 12 years. Right? 12 years, during which time we tell cancer patients, Bharat Biotech has a drug in the US, it is coming. Right? And everybody is waiting because the original drug, I tried to get a drug from Bristol Myers, it was $200,000 plus for 1 year. Right? So you can imagine, right? Now this takes 12 years. At this time, Bharat Biotech has its Tylenol, Desi Tylenol, okay? Now Bharat Biotech has to go through what is called as a market notice, a pre-market notice, where it will tell the other person, hey, I am going to compete because FDA has approved my drug, okay? Pre-market notice has to be given 180 days. Already you have waited for 12 years. This is like a bad marriage. You have stayed in it for 12 years. One more 180 days is not going to affect anybody. They are like, okay, whoever died would have died by now. I'll wait for 180 days. You give 180-day notice, right? At this stage, US law requires what is called as patent dance second stage. Okay? And by this time, I need you to appreciate one thing. Your biologic is in the market. There is a cancer drug that's in the market for a minimum of 12 years. That guy has been raking money in the market. Right? And poor Bharat Biotech, his flag will start flying, it becomes harder because you're paying your lawyers, litigating every stage, appeal, reappeal, en banc hearings, right? Depositions. You're finished. You're like, okay, you keep your drug, boss. I don't need this, right? Okay. So what is a patent dance? Patent dance is a pre-suit exchange between, this is the dating between the biologic and the biosimilar. My students only know the dating language better, so I use it, right? So these are pre-suit exchange between, before filing the lawsuit, this is the exchange between the biologic and biosimilar. You really have to see the dating game here, right? So you file the application. FDA accepts the application, right, and this is after 4 years. Then 20 days time where the biosimilar, Bharat Biotech, gives the biologic notice saying, hey, I have filed an application, right. Then the biosimilar gets 60 days. Now the biosimilar will give a list of patents. How many patents are there for Humira? One of you please look at your phone and tell me. How many patents cover the drug Humira? This is one of the blockbuster drugs of the past 2 years. Please tell me how many patents cover Humira. 250 applications were made. How many issued? 165 issued. Right? And this is only one drug. This is 1 minute in Srividhya's 1 semester class. Right? You can imagine. Right? So, biologic now gives a full patent list and then tells Bharat Biotech, here, you go file and fight each one of these patents, because we have 165 patents covering it, right? Now you get 60 days. In this 60 days, lawyers get to work. Whose lawyers? Bharat Biotech's, biosimilars lawyers. They give a patent list and then say, out of this 160, we will fight 20 because we think this 20 is invalid patents for whatever reasons, right? So they give a list. Then the biologic has 60 days. Biologic says, no, we think you have to really fight 100 patents. So they'll now have a contention. This is the pre-suit dating game that happens, right? When that happens, both lawyers negotiate patent list. So you will go there saying, please let me fight 20 patents. They will come and say, please fight 100 patents, and you'll eventually agree to fight 50 patents, right? So, and that will happen through several. There is a 15-day parties agree, parties don't agree. All of this is statutory. You can see the benefits of now following the American system, right? It's a highly litigious system. I want to go back to say why I say this now. America has a national unwritten policy of promoting innovation. So the minute you get a patent, Section 282 of Title 35 will protect it. We want the biologic company to sue the biosimilar. We want them to feel protected in the US. It works for the US. Following that in India, where, where it takes 12 years, 15 years to resolve a litigation, it doesn't make sense. This feeds into litigation. America's system is why we have so many law schools, lawyers too, right? That's not the system we follow. That cannot be the system we follow here, right? So parties exchange patent list, and then of course they file a complaint. At this point in time, wait, hold on, right? The first stage of patent dance begins. This is yes, okay? So this is the first class. In a 2-semester class, the first patent dance has just begun. There's so much more to happen in life here, right? And we want to follow that system. So then, of course, biosimilar waits for 4 years, application will not be approved. All of this I've already talked about, right? So I won't go there, right? Now, patent dance second stage begins when that 180-day notice is given, right? You know what the second stage dance is? You tell them, boss, FDA is approved. I am now going to market the drug. So Bharat Biotech is informing the other party. Now the biosimilar will say, oh, they only fought 50 patents. Let us file a lawsuit for all of the rest. How many more is there? 100 more is there, no? Let's file for the 100 more. So the second dance allows the biologic to assert whatever leftover patents they want to assert. And you still have to do this. You still have to fight that litigation. And this is the catch. Even if one patent is held valid, the biologic will survive. And the biosimilar cannot enter the market. Whereas the biosimilar has to invalidate every claim of every patent that's thrown to them, right? So it becomes a big issue. And this is where Bharat Biotech says, I will enter into a settlement, which Indian Economic Times will, big letters, Bharat Biotech now has settlement with Pfizer. Why? Because at this point they have gotten beaten black and blue. And Pfizer is telling them, look, we'll give it to you. How much money were you planning to make? $20 million. We'll give you $22 million. You go sell your drug in India. Quietly, they'll come and sell their drugs in India at that point in time. And it is a problem entering the US market, right? So that's where we are with regulatory approvals. How does this affect social responsibility? This is just some of the patents and the number of applications, right? The number of applications, let's take Enbrel, 154 applications, 74 patents. Alia, 134 applications, 91 patents. Just look at the numbers here, right? So these are the evergreen patents, and this happens pretty regularly in the pharma industry. And this is how IP directly affects your social responsibility, your ESG aims, right? This is where policies have to come in. Not done. I have more. Give me another 5 minutes. I have 5 more minutes. Here is the catch. Biosimilar must invalidate every claim. Patent owner needs to only prove single claim is there. They usually assert multiple patents. We have already talked about it, right? Okay. So what if we waited for the regulatory exclusivity period to be over? Let's say, okay. Already I have not talked about my prime area patents. There is 20-year patent monopoly. We are talking only about regulatory exclusivity. Runs parallelly with patents, right? Yeah. So this is the data exclusivity regime for US. 5 years for test data, 3 years for new use of known chemicals. Orphan products, same Tylenol used to clear baldness is 7 years, right? Pediatric exclusivity, Tylenol children is, or whatever, paracetamol child, ibuprofen children is 6 months. Biologics, 4 years. And 4 years of data adding up to 12 years of market exclusivity. You can see how long it takes for a company to kick in, right? How does AI affect this vis-a-vis your ESG responsibility? Right? We already see all of this. What is the biggest difference AI makes? Somebody tell me. In the healthcare field, what is the biggest impact of AI?
Testing known compounds, which compounds can work together.
And therefore?
Creating new drugs, evergreen.
Discovery has become faster.
Exactly. Discovery is faster. Otherwise, you give Tylenol to 50 patients for phase 2 trial, they have to categorize man, woman, Asian, non-Asian, Caucasian, African, tall, short, all of that had to be done using software. Now, AI does it, collects big data, segregates it in no time, right? So, how can ESG make a difference here? You can reduce this time because AI is already reducing. Exclusivity is for allowing clinical trial to happen. If clinical trial information time is going to come down, right? Why do we need this level of data exclusivity? Forget the US. Countries like India should say, no, I don't want to give this level of data exclusivity. We are, we have the AI capability. We are the, we have the software engineers here, right? And AI engineers, right? So it makes no sense to follow the US blindly in these policies. And this is where ESG will make, will create a difference. When I talk about AI and data exclusivity, no industry talks about reducing exclusivity period. It's virtually a only law conference issue, where pharma industry will come and push back, right? You never hear, that would be the ESG footprint from technology. You want a clear, long-lasting footprint. This would be an ESG footprint for AI technology. With me so far? There are other IP policies too, licensing and stockpiling and so on and so forth. But I'm not going there, partly because, I've already touched a lot. This is my last slide, I promise. Non-IP policies too affect, right, ESG and healthcare, but works with IP, right? Regulatory exclusivities, we talked about it. Preferential treatment clause for import-export policies within the region. If Europe can do it, why can't Asia do it? Why cannot India manufacture and sell it first to Philippines and Thailand? Why is it we have to sell it to Africa first? Right? If we can have regional integration, right, that makes it easier, better supply chains, better manufacturing, right, at that level. Regional manufacturing zones, regional genetic sharing mechanisms. WIPO has a new treaty here. That treaty can be effective. It can improve supply chain licenses. Tax policies, one of the most potent policies to help with IP and ESG. Patent boxes. This is a gift to all the management people. Patent boxing and patent amortization. So when you, and I'll just say this and get to this later. Integrating funding with innovation, venture capital. Venture capital now is abound in India. How do you integrate that with innovation, right? And I want to go to tax policies for a second, right? Transfer pricing and so on, right? How do you want to amortize it over a period of time, the investment you make to get a patent, right? Or do you want to give R&D tax credit, right, and say you only, or do you want to write off, say 30%, you invest X percent for a drug, do you want to do an R&D write-off? Each one has different implications and can lead to very, very strong footprints in the innovation market, right, and can help both innovation as well as your societal equity cause. None of this we do. India doesn't do any patent boxing, right? So these are some of the strategies then one can do, right? You delayed access, all of this, or the local manufacturing, delayed access, public health, regulatory hurdles, etc. These are all things that can directly address some of the ESG questions that arise from intellectual property rights, right? With that, what do we need going forward? One is strategic vision, more academic research. I am an academic, so I can't help myself there because it's impartial. Academic research is interdisciplinary as well, right? And we need that to have legal regulations and policies to effectively work with corporate efficiency. So management and legal needs to really work together to create these type of lobbies and policies. So with that, thank you. I took more time than I thought I would. Thank you. So any questions, please? I think you had a question, no?
Yeah, so a couple of slides back, you had the number of patents filed, number granted.
Yeah.
The next column was average duration.
Yeah.
Is that in years? 40 years, 45 years?
Absolutely. So I usually take time to explain that. You're talking about the one, this slide, yeah. This one, no? You're talking about this. Yes, look at Enbrel, right? And that's what is called evergreening.
Why do you have different 35 to 49?
So patents is for 20 years, right? So Tylenol cures headache, okay? And you get 20 years from the date of filing, okay? Now 2 years after you file Tylenol and you get, now the company will file a second patent, and this time for Tylenol in liquid form, okay? So now you get 2 years plus, right? Another 1 year later, Tylenol for children. So you add 1 more year. You wait 4 years, okay? What happens in your body when you ingest Tylenol? Your hydrochloric acid works with that, right? So now, yeah, you go and patent that byproduct from your body. That gives you another 10 years. A generic that has to enter the market now will have all of these patents that they have to deal with, right? One of the most famous cases is actually from Smithline Beecham. I forget, I think Claritin. I don't know if it's an allergy drug. The holder of the Claritin patent went and got a separate patent after 10 years or 5 years on the metabolite that's formed in our body after ingestion. So I take Claritin, body acids or whatever react, and then there is metabolite that's formed in my body. He went and took a separate patent for that metabolite and kept it, didn't use it. Then I think Abbott or some other generic drug company wanted to introduce a new generic drug company. Generic drug, when the first patent expired. They said, perfect, our patent is expired, but all of the patients who buy your drug will ingest it and will infringe our second patent. So how are we going to deal with it? You are contributorily infringing our second, third patents, right? It became one of the biggest disputes both in UK as well as in the US. And that's the evergreening process that we have, right? Leaves a large footprint in some of these areas. Sorry, any other question? I hope that helps. Okay. Any other questions?
So from the metal perspective, trade perspective, we use lithiums in electric vehicles also, right? Lithium is also a valid drug, prescription drug. Many of you might not be aware, but so yeah, when we are trading the drug on the metal, what are the consequences that we have from the patent perspective?
When you're trading the drug lithium, you're talking about?
I mean, people have a choice to make for transport or for health, right?
Yeah.
So, what is it from the trade perspective?
So let me tell you from the patent perspective, right? So lithium can be used, like you said, for batteries. Lithium can be used as a drug for certain things, right? So you can have separate patents covering lithium for drugs, okay, and covering lithium for batteries. The battery lithium will have its own life. That patent will have its own life. The drug patent will have its separate life. So when you trade lithium, right, as a drug, then the question is whether that patent is affected. If that patent is affected, then it becomes a problem. I just want to add one more thing. There are some patents for new use of an old drug, like Tylenol to cure, cancer, right? Aspirin is a great example. Viagra is a great example. Viagra used to be a blood pressure medication until somebody said, oh, I like the way my blood pressure is going down. And then it became a drug for something else, right? So in these cases, there is a separate patent for the boring Viagra. Okay, and that has its own name. That's where trademark comes in. And that will be sold at a different price. I mean, who buys Viagra for blood pressure, right? Go on.
The grade, medical grade or defense grade or the transport grade, while manufacturing, then what are the restrictions that we have?
Absolutely. So if you manufacture as a battery grade, and you have a license to manufacture for that purpose, that cannot be used for medication. And if you do use it during an FDA inspections, they'll catch it. And then it becomes an issue at that time. Yeah? Yeah.
ESG is for environment, but you said that was also include public policy environment.
So environment is a large word, right? So you can, when you talk about environment policies, and that's really for environment scholars too, right? It need not just be, the environment in this class, right? So it really can be defined to be much more inclusive rather than a strict definition. The more you include, you create a more broader definition, it brings in public policy angles to it from public health perspective. That's what I meant by environment. Yeah?
In the middle of your seminar, you said that this particular conversation is being talked only in conferences.
Right.
And at that time, pharmaceutical companies push back. And as we know, the biggest lobbyist in US Congress is the pharmaceutical company.
Yes.
The question is, do you consult with companies like that? The question is.
So that's a great question. Go on. Yeah.
Wouldn't you, if you are talking about that in conferences, wouldn't you be receiving less consultation? I'll be very frank. As far as IIMA goes, not known for much of its research as far as it goes. But consulting projects, all the profs have consulting projects with almost all Fortune 500. The conflicting interest between an academician and a consultant.
Correct. So that's a great question, and I will tell you this, right? And I say this in jest, and then I'll answer you directly. Okay. So when you are a management consultant, you talk about corporate issues. So you can leave that side, your academic side, and you are focusing on what is good for the for the company, right? If your consulting is for policy purposes, as a lawyer, you really have to give them the other side too, right? You're obligated to. So law professors, it's not that we don't, we either, it's either for God or Satan. We are consultants too, but we can be for God or Satan, right? There are some companies that are in the middle, serving both, and we will be there, right? But, okay, it's also a fact that a lot of times in these things, people know, oh, this one, her policies or suggestions would help this type of companies. Like, if there is ever a company that would approach me, I always say, and I've said this several times, right? For a generic drug company that has interest in getting into the US, somebody like me would be perfect, right? But a big pharma would say, this one, keep out of, get her out of it, yes, sir. Right? So that's how the thing will work.
I'm really surprised that you answered this question. You could have invoked the attorney-client confidence.
That's true.
The second question is some of the companies, for example, Abbott. Abbott, at a particular point of time, separated its R&D department or patent manufacturing department, which is AbbVie. They separated it. And at a particular point of time, at least I think currently, AbbVie is valued higher in terms of market and everything than Abbott. The question is, now Abbott is in a particular struggle in which they are unable to create patents in AbbVie is in a particular state that they are unable to create in their original sense. So they are going for inorganic growth by acquiring other companies which have patents. Now the question becomes, if the legal process is this much of a long drawn out grey area, how much they are betting crores and crores on a particular company,
No, it's not like that. It's my first slide where we said initially we thought patents is good for innovation, right? So AbbVie is at that point where there is no innovation. Then what do? You have a barren land. Now you have to sell the barren land, put a shed there, bring a bunch of cows there and still make money, which is what AbbVie is doing. That is why Lipitor has so many litigations. Lipitor was a blockbuster drug and then suddenly 20 years got over. So now you have to find ways to survive in the market, right? That's why you have these evergreening. They have to find ways to extend their market exclusivity, right? So that's what happens with AbbVie. Abbott, unfortunately or fortunately, is a Canadian company. Canada has some very good policies that actually allow for healthcare access.
And morals as well.
Of course, right. Right? So, Canadian policies, in some ways allow Abbott to actually, thrive in a different market, and that's the reason. And that will happen with Indian generics too. When Bharat Biotech launches more innovative products, it will be called whatever, then, Bharati or whatever, but it will be the innovative wing. And that, that will happen differently and, that will have its own life, right? And that will strategize differently. And unfortunately or fortunately, that's the pharmaceutical pyramid. As you go up, you still have to, manage both sides of the pyramid, right? Any other question?
So we have Ayushman Bharat Health Assurance schemes in India, and why do we know? Isn't it fair enough to understand that the government is also trying their part in imparting sustainability, overall health environment sustainability we are talking about? So what is your take on this government's?
That's a different question altogether. That is healthcare access policies. This is IP policies affecting healthcare. That is, it's almost like universal healthcare in Brazil, Medicare, Medicaid in US, right? They create middle people and then they access that, right? So it's more like that. So those come under medical policies, right? And how, I mean, that's a system by itself. You can, you can do 2 generations of studies over that itself, those negotiations and so on.
Follow up. What do you think on the execution of United Health Insurance executive?
I don't know that story. Is it in India or there? What happened?
Yeah, the United Healthcare executive was
Oh, yesterday a person was assassinated or something.
I see. I
much far better as compared to US in that perspective.
It's getting there because I also go to hospitals. We are getting there pretty quickly, but yeah.
Say that the policy makers are really safe here in India compared to US. I'm just being proud about it.
Because of the absence of guns.
Yeah, that is true. These things are intertwined. Yeah. Yeah. No, not really. Because, as we grow, the policies have to be carefully calibrated. It's harder because you have competing lobby groups, right? So it's really difficult to. So I don't think policymakers are any safer or any saner or any better. I mean, everywhere it's the same, right? So that's why academia has its own special place, right? Whichever area. That's why academia has its own special place, right?
Local manufacturing, another slide. You mentioned about India wants to do this. Local manufacturing is an issue with the WTO.
Yeah.
But when Mark Cuban wants to do it, we'll start changing. What exactly is that? I couldn't get the whole.
Okay, so no. So local, see, when we manufacture, and this is only to healthcare sector, right? So if India wants to manufacture, say, a patented medication that is patented by Pfizer, the international trade obligations under the TRIPS agreement will prevent locally manufacturing. Either Pfizer can import it into India, or India can compulsorily license it, which means a WTO dispute where India has to defend its position, right? Or it can get a license from Pfizer, voluntary license.
Pfizer's subsidiary in India can do that?
If Pfizer allows that, right? But it will again be Pfizer's subsidiary in India. Then Pfizer has to decide whether it wants to price it differentially in India, right? Now there is a concept called parallel importation. So for example, let's say Tylenol is the cancer drug that we talk about, is sold for $800 in the US. Pfizer subsidiary manufactures it in India for $20. There is nothing that will prevent Srividhya from buying Tylenol from here and taking it there and selling. So drug companies don't want it because it creates a parallel black market. So they would try to sell it even if through the subsidiary at the same price. But we like local manufacturing, by we, every country, because then you can price it according to your GDP, right? So that the international trade regime prevents, right? People like Mark Cuban or, so California was locally manufacturing within the US. So they were trying to defy the US norms and manufacture there. Africa has basically said regionally we want to locally manufacture. And that's something Asia has to do. I say this in some of the Asia things too, because then as a group you are locally manufacturing, as a group you are catering to, that region, right? Mark Cuban has started, because healthcare access is so bad, he has started it's called some cost plus or something, cost plus pharmacy, where he has completely eliminated the middle person.
So it's pretty much like smuggling generics from India and then making it under his.
But some of that will not be patent protected. So the first question for these is it patented drugs or non-patented drugs? If it's patented drugs, then it's subject to all of these international regulations. If it's non-patented drugs, do we have the technology transferred? Does it include patents? Of course, you can easily get. What about the know-how? And that was the biggest question during COVID. Yes, the hard IP like patents was available, the soft IP like know-how technology was not available. So that becomes the conundrum there, right? Yeah.
So, Prof, when we talk about the WTO and the TRIPS, there's an internal logic to the IP systems, which is translated to, let's say, compulsory licensing, local network, local working conditions.
Yeah.
And then there's an external logic, which traces in terms of healthcare services, healthcare access policies. So, when we talk about within the lobby groups at TRIPS, why does the external logic never trace upon the internal logic, even when we're discussing TRIPS Plus?
So, okay, that's another completely different policy. So, define your external logic to me.
External logic can be any set of infrastructure which has been created as a response to the internal policies. Like, for example, within copyright, we can talk about the CDL systems.
Yeah.
Within patent, we can talk about the universal healthcare systems.
Right.
These are external logics to the internal IP mechanisms.
Yeah.
So, when we are talking about the international negotiations, let's say TRIPS Plus,
Yeah.
why does the external logic never trace on to the internal logic? Why can't these cross-pollinate within the policy-making space?
So, part of it is part of the negotiating bargaining chips, right? So, especially when it comes to internal logics, right? And working with the external logic. So, so let me go back to TRIPS Plus, right? TRIPS Plus has been a factor of what is called as minimum standards. Everybody has to set the minimum standards, right? So, when you talk about internal logic, I want you to think about it. Why did countries agree for minimum standards? Why couldn't countries say, that's not the minimum standard, that's the maximum standard. I am not going to go above that. But countries didn't do it. So, they agreed to keep it at a minimum level, right? So, then when they trade at this level, your trading partner is going to poke holes on where they can, they can send their products in. That's the trade regime, unfortunately, right? I mean, that's how sales work in every country, right? If you need something so much, you're going to pay more, right? So, that's the same thing with TRIPS Plus, right? So, these two don't cross-pollinate because that space is the negotiating bargaining chips that other countries take. Does that make sense? Yeah. But it's not that it cannot. There is scope, but then...
I mean, the discourse around the interaction of WIPO and WTO. So, they say that as we move from WIPO to WTO, the trade became like a barrier. If this negotiation, if this cross-pollination could happen, the infrastructure of access and the logic of IP can cross-pollinate, and their solutions might lie.
Part of it is because WIPO has now become the administrative wing. They don't want to get into, they want to do the soft IP, right? Whereas WTO has become the very trade focused organization. They don't want to get into anything that is untrade, So that's the, that's where the gap is. Right?
So we have such a 3D and Section 84 of patent act.
Yeah, compulsory.
So far we have granted very few, I think one so far to my knowledge. And that has a backlash in US.
Yeah.
US here,
Yeah.
So why India could not grant more compulsory licensing and trading, more ban on trading?
So, 2 or 3 things. One, this is again where management can actually come in, right? So, 3D prevents this patenting of smaller things, right? So, lot of times when a salt is patented, what will happen is 2 years later, they will, patent the esters, ethers, polymorphs, the salt form, water soluble form, each one of these, right? 3D clearly prohibits that. It's not that US doesn't do it. US also sometimes prohibits it. But US hides it within the MPEP and the regulations. Right? But we put that up front in the statute. And because we put that up front in the statute, it became super contentious. Right? And because it became contentious, right, and the US took us to the whatever, all of that USTR, special 301 disputes and so on happened. Now when WIPO brings their courses and teaches here, they are like 3D is it may be okay with TRIPS, but it is still violative of TRIPS. So, that's where your WIPO doesn't give the full picture sometimes. I'm not blaming WIPO, but nobody gives because it became so contentious that people don't talk about it, right? Section 84, in fact, India wanted to, after that, compulsorily license Dastanib, right? After the first compulsory license by Nexavir and then Dastanib, right? But before that could happen, US had, the special 301 and then they increased India to the priority foreign country. Then they had an OCR over, it's like out of cycle review or something like that, right? So we made submissions for all of that. It became so much that our, diplomats said, that's our IAS officers and all, they said, look, we are going to take a step back because it doesn't, help us. This is where lobbies and diplomacy helps, right? People like USTR comes to India, we read about it in the newspaper and they say, look, you can't do this. You do this, Brazil is going to do this. Brazil does it, South Africa is going to do this, right? So it becomes a, process that happens. So this is where the legislature and the diplomats always face opposite sides. The legislature will say, no, we'll go kick the US and get you Dastanib. The diplomats will quietly say, no, we can't do it because then they're not going to give us this trade or that trade and it becomes an issue there.
Public policy question, not necessarily in law, but while development of COVID vaccine in US by US manufacturers, mRNA vaccines, the government actually funded those companies. They basically gave the companies some money.
COVID vaccines. Oh, that's a big issue. You're talking about the NIH issue, no? Absolutely. Public funded innovation getting private property. I just made a submission to NIH about it and it's now a big question in the US. Because these are public money, you take it, you create private property, right? And then distribute it at, at the private property rates, right? So NIH, when the Trump administration was there, Trump administration actually wanted to amend that regulation to say that this area NIH will not interfere in. And then NIH put that for public comments. It received 84,000 comments, which is huge in the US. I mean, 84,000 is unheard of in the US. So then came Biden administration. So then they opened it up again and they realized they had to rework it. So now there is something called the NIST, National Institute of Scientific something. NIST put new guidelines where it said maybe we should consider what happens with public funding. So the act that actually affects this is called the Bayh-Dole Act. Right? So, Bayh-Dole Act has a provision called margin rights. When public funded innovations are sold at such a high price, then they can exercise, the director of NIH can exercise margin rights and actually tell them to reduce the cost of drugs. Right? There has been at least 5 petitions over the past 15 years. Every single time the director has said there is no need to margin. And then COVID came, it has become a big issue, but so far no amendment has come in and of course COVID is gone and people have forgotten, we have new issues and now, in the new presidency we expect more. Yes, that is gone.
But this raises a question in which, in US, they go to Canada to buy insulin and come back and that is there.
Right.
In India also now this insulin and evergreen insulin variants.
Right.
But the thing is, it happens at an individual household level. They ration insulin.
Correct. Yeah.
They don't use the correct quantity that they have to use.
Yeah.
Now becomes the question: if we are supposed to protect patent because it gives innovation, it provides innovation, then shouldn't just in healthcare only let the government fund the budget of R&D for innovation in healthcare and let the private players go? What do you think about that?
No, that Brazil is trying with its universal health care. NIH tries to some extent and it has not been successful, right? So in a country like India it's even harder because, in order for that to be successful, people have to be willing to pay taxes. A large amount of taxes, a percentage of money should go as tax. then government will have the money to fund it. If you don't have it, it becomes a problem. That's where the problem arises. Right? More questions? Okay.
Thank you so much.
Thank you. You've been great.
We can continue the discussion also.
Thank you.